All right, good afternoon, everyone, and welcome to today's session, DEI initiatives in the crosshairs of the administration, what nonprofits need to do to mitigate their risk with attorney Jeff Tenenbaum. My name is Carrie Bedell, and I'm the Executive Director of the Greater Washington Society of CPAs, and I will be your session host for today. I want to offer a special welcome to those of us joining us for the first time from our fellow state CPA Society partners. The nonprofit sector is not only critical to our membership here at GWSCPA, but to the health and vitality of our country. I know news has been coming at us fast these past few weeks, so we're happy to be able to provide some guidance as we work through impacts to your organization and your clients. This will be the first of many sessions we'll be hosting for those of you leading the sector, so we hope to see you again. Before we get started, let's take care of a few logistical items. If you're having any issues during the webinar, feel free to reach me or any of the rest of the GWS CPA staff in the chat. For CPE Credit, you're required to answer polling questions, which will pop up on your screen periodically. If you do not see the polls pop up on your screen, but you hear the chime sound, just put "I'm here" in the chat, and we'll use that to record proof of your attendance. I'm going to encourage you to use the chat tab to share your thoughts with other attendees, but please ask questions of our speaker via the Q&A tab. Jeff's going to get through some presentation for the first half of the hour and then take questions mostly in the second half, but you can feel free to post your questions throughout. At the end of the session, you'll be redirected to an evaluation page, and you'll also receive an email with a link to the evaluation. At the conclusion of the session, all poll responses, as well as your entry and exit times into the Zoom platform, will be reconciled, and your CPE certificate will be emailed to you. Now, it's my pleasure to introduce Jeff. And Jeff Tenenbaum is widely regarded as one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, commentator, and expert witness on nonprofit legal matters, and is a longtime GWSCPA friend. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, a 6-attorney boutique law firm focused exclusively on the legal needs of nonprofits, Jeff counsels his clients on the broad array of legal and sensitive business and governance issues affecting nonprofits. Among numerous other honors and awards, Jeff is the recipient of Association Trends and CEO Updates 2025 Association Industry Partner of the Year Award. He was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award and has been one of only a handful of leading lawyers in the prestigious U.S. Legal 500 not-for-profit rankings over the years. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, which is only slightly more popular than his second and much more interesting book, Quarantine Cocktails. He currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee and on several ASA committees. Excuse me. And now, with that, the floor is yours, Jeff.
Thank you, Carrie. Welcome everyone to our webinar today. I apologize in advance if I have any Wi-Fi connectivity issues. Due to weather issues, I was not able to get back to DC in time for this, so I am doing this webinar from the lovely confines of my Charleston, South Carolina hotel room, which does not have the best Wi-Fi. So if I cut in and out for a second, hopefully not, just bear with me. But we have a lot to cover today, and while those of you who've heard me speak many times before know that I generally like to take questions throughout when I'm speaking here, I thought it would be a little more helpful for me to go through what I want to cover first, because there's a lot to digest, and then it'll help, I think, be able to frame the questions that you're going to have and my answers to those questions. It'll make it more helpful and more responsive. Also, before I forget, I wanted to highlight a new article of ours on this topic that we just published about a week ago. It is on our firm's website. Maybe if someone from the GWS CPA team can put it into the chat, it's www.tenenbaumlegal.com. And if you look under the publications tab, you'll see the article right at the top with an obvious title. And it's a pretty comprehensive article that I would encourage you to read and to share with your colleagues and others who might benefit from it. And then there's also, that article contains a link to a prior article that I wrote about how nonprofits can mitigate their risk from DEI programs about a year ago, or less than a year ago, but prior to the Trump administration. And so I'd encourage you to look at both of those articles, but it's important for you to understand that because it's going to very much factor into the type of legal analysis that we're talking about here today. And actually, that if you can scroll down to the one right underneath that, that's the one that has the other hyperlinks in there, the different version of the same article. It's important for you to understand that while we are here today, because of the recent actions of the Trump administration, particularly some executive orders that I'm going to talk about, and some other memoranda that have come out of the Trump administration and some federal agencies. And that's the headline. That's why we're all gathered here today. some of the legal risk in this area, particularly for private nonprofits like yours, the ones that you work for, the ones that you represent, come from other parts of the law that have nothing to do with these new executive orders. And so while the executive orders are certainly casting a spotlight on these issues, um, and they are definitely getting people's attention, particularly because of some of the references to nonprofit organizations themselves, in order to understand the legal risks and other risks that you face in this area, it's important for you to understand the different areas of potential legal exposure, and they're going to be different for every organization. We have counseled already, my colleagues and I have counseled dozens of our nonprofit clients on how they can mitigate their risk in this area. We're in the middle of working on a number of kind of written analyses, memoranda that are analyzing their different issues. And as you're going to see when I get through this today, you have to approach it from lots of different perspectives. For instance, whether you get federal funding, grants, cooperative agreements, contracts, or loans, whether some of your DEI, diversity, equity, and inclusion initiatives are in the employment area with respect to your employees. And then the third big one is whether or not any DEI initiative, and I'll explain more what this means, involves any form of a contract, like a grant agreement, a fellowship, a scholarship, things like that. And I'll explain why that's relevant as well. And so you have to analyze it from those different perspectives. I've heard people say, do we have to change this? We have this sort of committee. We have this sort of internal initiative for our staff. We have these sort of working groups at our conference, or special interest groups within our association. Do we need to get rid of those? Do we need to eliminate the DEI statement on our website? And I can't give you a straight up yes or no, you have high risk, low risk in this area, because it all depends on some of these other factors. So it's important for you to understand that. It's also important to understand that any federal administration only has certain ways that they can, whether you want to call it go after or attack or penalize a private nonprofit organization, and especially if that organization does not receive federal funds, and especially if the DEI initiative is not in the employment area. There is likely very little, and assuming we're not talking about criminal activity or things like that, there's likely very little that most federal agencies or the White House or the Department of Justice is going to be able to do to come after or attack your organization. So that's important for you to keep in mind. So, setting the stage with all of that, let's dive into it a little bit. As you probably know, in the first couple of days of the administration, President Trump signed a flurry of executive orders, one on January 21st called Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which I'll call the DEI executive order, which was designed to ban both public and private sector programs encouraging DEI. And then there was another executive order called Ending Radical and Wasteful Government DEI Programs and Preferencing, which I'll call the Environmental Justice Executive Order, that terminates environmental justice programs within the executive branch and targets federal contractors and grant recipients that advance DEI and environmental justice. And there's certainly an overlap between those, and I'll talk more about those. In addition, shortly before her confirmation by the U.S. Senate on February 5th, U.S. Attorney General Pam Bondi issued a pair of memorandum to U.S. Department of Justice or DOJ personnel directing the department to eliminate internal practices relating to DEI and environmental justice and directing various elements of her agency to, quote, investigate, eliminate, and penalize private companies and universities, including nonprofits, that have illegal DEI programs. And I put that word in air quotes because it's going to be a common theme here that I'll be coming back to. And the short answer is we don't know right now what DEI programs are illegal. There was one reference, I can't remember, I think it was in the DEI executive order that said that all DEI programs are illegal. Well, we know that's not the way the law works. In the way the law is developing, which I'll talk about shortly, there are some DEI initiatives that may well be deemed to be illegal, but we just don't have any definitions yet. Pam Bondi instructed DOJ officials to enforce federal civil rights laws to abandon what she calls illegal discrimination and preferences, and she outlined strategies for launching criminal and civil investigations. Um, while these executive orders and Pam Bondi's enforcement memorandum were not surprising, given the widespread criticism of DEI that we heard during the campaign and programs that are considered, quote, woke by the political right. The text of the directive surprised many with their explicit mentions of private sector and nonprofit organizations, many of which, as you know, have long established programs dedicated to DEI efforts. At a minimum, these directives most definitely signify the administration's intent to pressure private sector organizations, including nonprofits, regarding their DEI practices. And certainly a more expansive view of them, I think, foreshadows an aggressive effort to challenge DEI programs through lawsuits and regulations, targeting organizations that the administration perceives as ideological or political enemies of the current administration and its policies. Now, for those of your organizations or your clients that receive any form of federal funding, grants, cooperative agreements, contracts, or loans, um, you are at the highest risk and you need to pay the closest attention to these executive orders and memoranda. And one thing that has certainly gotten people's attention is that we're already seeing it implemented in the DEI executive order. There is a requirement for federal grant, cooperative agreement, and contract recipients to affirmatively certify that number one, their organization, quote, does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws, and two, that the organization is in compliance with all federal anti-discrimination laws that are material to the government's payment decisions for purposes of establishing Federal False Claims Act liability. That's really important because what it means is that you have to certify under penalty of perjury that if you receive federal funds going forward as a condition of continuing to receive those funds or getting those funds in the future, that your organization does not operate any programs promoting DEI that violate any federal anti-discrimination laws, and that reference to the False Claims Act basically ties it. So the False Claims Act is a longstanding federal law that makes it illegal to essentially defraud the federal government. And it comes into play in lots and lots of different areas, from government contractors to Medicaid and I'm sorry, Medicaid and other things like that. Um, and so by having to certify your compliance with all federal anti-discrimination laws and tying it to materiality for purposes of the False Claims Act means that your organization is subject to potential both civil and criminal penalties if that federal agency determines that that certification was not accurate. In addition, we don't really quite know yet because this is also new, but it would not be surprising, as is typically the case, to have these certifications be what's called flown down to subawardees, like subrecipients and subcontractors, meaning if you have subaward recipients, then you're going to have to get the certification from them that they comply, or that you're going to have to certify that all of your subawardees comply. Your organization itself might be a subawardee. So we're going to have to see how this gets carried out in practice, but it's definitely something to keep your eye on. Keep in mind, executive orders certainly carry the force of law. They're legally binding and can be enforced. Um, and generally, they are not supposed to create new law. They're supposed to generally dictate how the executive branch will operate in carrying out existing law. But in the past, and certainly here in this administration, we expect these executive orders to be a powerful policymaking tool for the Trump administration and a tool to test and implement new economic and social policy. Now, some of you are probably thinking, well, we've heard about all this litigation challenging these executive orders and other actions of the administration. The pause on federal funding, which was later revoked by the administration and also enjoined by the court, by a federal court. And there is litigation that is ongoing. This is a very deliberate strategy by the Trump administration. They expected this litigation. They want this litigation. They want to challenge these legal actions and take these cases all the way up to ultimately U.S. Supreme Court to try to make new law in some of these areas. My personal guess is that they expect that in the end, the U.S. Supreme Court will uphold some of the things they're doing, might reject some of the things that they're doing, and come out somewhere in between. But that by throwing everything out there and pushing the envelope on a very aggressive legal strategy, they hope that they can change the law, particularly when it comes to executive branch powers vis-a-vis Congress. So, all of that being said, I do not recommend, especially if you're a federal award recipient, to obviously you want to keep track on what's going on with the litigation. You want to keep track on what sort of potential liability you might have in light of these executive orders. But I do not recommend that you put your stock in whatever stage the various pieces of litigation are. And as we're going to get into, I think you need to take, if you want, depending on your risk tolerance and the extent of your risk, you're going to want to take some practical steps now to help to mitigate your risk. Now, you might remember the U.S. Supreme Court's decision in 2023 involving college admissions and affirmative action that basically made it illegal to consider race and other protected characteristics as a preferential factor in college admissions, essentially adopting kind of a reverse discrimination argument. And while that case only involved and only applied to college admissions, the rationale, the reverse discrimination rationale behind the case, basically saying, for instance, if you're giving someone a preference based on their race, that is discriminating against someone who does not have that race. For instance, a white male, and that is illegal and illegal discrimination. And so, since that court decision, we have seen a rash of litigation making that same argument in the employment setting, in contracting, which I'll get into. And I fully expect, and many other legal observers fully expect, that that rationale behind that case will continue to work its way through the courts and change the way that we analyze anti-discrimination laws, um, especially at the federal level. So, let's get into something else. The DEI executive order also had directed federal agencies to submit recommendations for enforcement of the civil rights laws, and they asked um, to identify discriminatory DEI practitioners, and they asked federal agencies to recommend investigations and potential litigation of DEI programs of large nonprofit corporations or associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. This explicit reference to nonprofits and associations has certainly generated a lot of concern among nonprofit and association executives, and it's caused a rush to evaluate whether any nonprofit DEI practices could be considered discriminatory. Also, among the recommendations that Attorney General Pam Bondi issued are proposals for criminal investigations, although I have a really hard time understanding how um, a DEI practice of a private nonprofit organization could lead to a criminal violation outside of the False Claims Act issue that I explained earlier with the certification that has to occur when you receive federal funds now. And Pam Bondi also asked for up to 9 potential civil compliance investigations. Of course, these executive orders also directed federal agencies to terminate their own DEI programs and initiatives and certain requirements on federal workers, like they can no longer use pronouns in their email signatures and things like that. But that's not the focus of today's webinar. Today's webinar is the focus is on nonprofit organizations. Um, Something else to keep in mind with respect to this executive order. Um, the, as I said, neither executive order did anything to elaborate on what the White House views as discriminatory and illegal. Um, and the directives somewhat obscured the consequences of being on an administration list of organizations providing DEI training or programming for the federal government, although the clear implication is the loss of federal funds. And we already have had some clients being asked questions by their federal agencies. These are nonprofit clients of ours that provide certain types of training or programming for the federal government, generally under contracts, and asked, to certify that none of their programming. So some of the agencies are asking, and the certification asks whether you are providing any illegal, any DEI initiatives that are illegal or discriminatory under the law. But some federal agency officials are going well beyond that and saying, please let us know if any of the training you do even has any references to DEI, which is much broader than just being illegal. And so one of the things to keep an eye on here is not just what the short 2, 3 page executive orders say, but what's coming out from the federal agencies as well. And the federal agencies are very much responding to this executive order and reaching out to federal awardees to ask these sorts of questions. And some of those questions are different than what we see and more expansive than what we see in the executive orders. There was also a report last week, or maybe it was a week before, that staff at the National Science Foundation, which is a federal agency, have reportedly been combing through thousands of active science research projects funded by the federal government, funded by NSF, and looking for flagged keywords. And some of those keywords are and include women, diversity, minority, institutional, historically, and socioeconomic, along with dozens of others, to determine if these research activities include things that would violate the new executive orders. Scientists who receive NSF funding are already put on notice to cease any activities that do not comply with the executive orders. Um, we have also heard from some clients who have heard from their maybe friends at federal agencies that they've worked with for years that some federal officials are combing the websites of federal award recipients to see and I don't know what type of artificial intelligence or whatever might be being used to examine websites, but certainly searching for certain keywords. And so if you are a federal award recipient, as I said, that really puts you into the highest category of risk, in my opinion, right now. That's something that you really want to actively consider. I'm not saying you have to do it. I'm not saying that, having certain DEI trigger words on your websites or other publicly available documentation is going to be a problem for you or cause you to lose your federal funding, or if you have a DEI related section in a training program you provide to the federal government. But certainly, if you're somewhat risk averse and if you don't want to jeopardize that federal funding, that is something to keep in mind. Now, let's move on from these executive orders because while the executive orders are certainly putting a laser sharp focus on these issues, and are getting federal agencies to respond and are getting nonprofits to respond. Many nonprofits, probably even I'm guessing the majority of those on this webinar today, are not federal fund recipients. You don't get federal funds directly or indirectly as a subcontractor or sub-grantee. But even if you don't, you still have to be concerned about risk. I wrote this whole article last year about how nonprofits can mitigate their risk from DEI initiatives, and this was before the Trump administration. And the two areas that I focused on were three areas that I focused on the most in that article and that I want to touch on here today. One is employment law. And to me, this is the second highest, if not equally important area of risk. So when I say in the employment setting, we're talking about anything relating to your employees, not governance, not board practices, not member practices if you're an association, but employment, internal employment policies, practices, other initiatives that might fall into this DEI category. Of course, remember that federal employment laws are enforced by the Trump administration through federal agencies such as the U.S. Department of Labor and the Equal Employment Opportunity Commission. These are agencies that enforce federal employment laws with respect to private employers, including nonprofit organizations. You couple that with the clear direction from the U.S. Supreme Court in the college admissions decision that rejected race-conscious admissions in higher education and it essentially adopted a reverse discrimination kind of construct that I fully expect that to make its way into the body of employment law. There has not yet been a U.S. Supreme Court decision that has done that, but I fully expect that that will happen. either this year or next year. And that will very much change the legal analysis with respect to employment. Like, for instance, it this reverse discrimination logic of the Supreme Court's college admissions program and reruling it's likely going to threaten employer programs, your own programs, that allow race to be taken into account, such as if members of a racial minority were previously excluded from a job category. The current state of the law says that yes, you can do that. Like, for instance, if you have a certain minority group that were previously excluded from a job category, you are allowed to take race into account. You can also remove obstacles such as unconscious bias that prevent employers from having a more diverse workforce. That's the state of the law today, but that might not be the state of the law 6 months from now. And that, of course, I'm talking about federal law. Um, so it's something you're going to very much have to keep an eye out for, to pay very close attention to, and to work with your legal counsel and especially employment lawyers that understand how these things play out in the employment setting to review all of your employment policies, practices, trainings, handbooks, other things like that, um, to ensure that you are not generating too much legal risk. And there are a lot of employers that are already making changes in that regard in an effort to help mitigate the risk, potentially stave off private lawsuits by aggrieved employees and things like that. And certainly, though, if your nonprofit has things like a staff leadership acceleration program or an internship program that's only open to members of underrepresented minority groups, those are likely already on very suspect legal grounds, and you really ought to take a close look at those. And the way to think about it in the employment setting is you really want to make these initiatives non-exclusionary. So, for instance, if you want to have some sort of a program for, early career or mid-career folks, within your organization to help promote and accelerate leadership training, things like that, that's absolutely fine. But don't limit eligibility in some exclusionary way, especially as it relates to things like race and sex. Keep it open to anyone. Obviously you can limit it by where they are in their careers and things like that. But you really want to put that anti-exclusionary lens on all of your employment policies and practices. And of course, keep in mind that there are state and local employment laws across the country that do not mirror and marry up to what's going on at the federal level. So, for instance, in a number of states, in DC, it's illegal in the employment setting to discriminate on the basis of sexual orientation or gender identity. Those laws haven't gone away. Those laws are very much still in effect. They can be enforced by state and local, like equivalents of the Department of Labor. They can also be enforced by private litigants who bring claims in state courts for violations of those laws. And so you have to marry up what you're trying to do to mitigate your potential legal risk on the federal employment side with still complying on the basis of very much applicable and enforced laws, particularly in more blue states, at the state and local level. And you just can't ignore those. That can create a lot of legal risk. And finally, keep in mind that in the employment setting, the employment laws apply based on where the employee is principally working from, not where the employer is headquartered. So if you are like many nonprofits and you have lots of employees in lots of states, you have to comply. Each employee in each state is governed by that state's employment laws. I told you there's two other areas of big risk. We got federal funding, we have employment law. Third big area is contracts. And you might say, contracts? That makes no sense to me. Well, believe it or not, there is a section of the Federal Code, 42 USC Section 1981. It was part of the original Civil Rights Act of 1866. And it came about after the end of slavery, and it prohibits racial discrimination in contracting. Prohibits racial discrimination in contracting. Now, this law, this provision, Section 1981, hasn't been talked about in decades and decades. But after the U.S. Supreme Court's affirmative action college admissions decision, it has gained new prominence. And in fact, the individual who brought the Harvard and UNC college admissions cases through a nonprofit that he formed another nonprofit called the American Alliance for Equal Rights, which has brought a number of lawsuits against certain programs that involve contracts, grants, fellowships, things like that. And you might say contracts, but if you think about it, almost any grant is going to have a grant agreement. Any fellowship, any scholarship is going to have some sort of agreement attached to it. And if those agreement-based programs are only limited to, say, people of certain races or other protected characteristics, but especially race, Ed Bloom has made the argument that that is discrimination in contracting on the basis of race, discriminating essentially against white men, for instance. Um, and he has brought a number of these cases. In almost every case that I have followed and that we have followed, um, the uh, the defendants abandoned their programs. They chose to just abandon the programs and not continue to litigate. One case was brought against Fearless Fund, which is a nonprofit based in Atlanta, I believe, that had I won't bore you with the details, a single member LLC called Fearless Fund Management LLC. There was a Black women run venture capital fund that made grants to Black women owned businesses, $20,000 grants. But you could only apply for a grant if you were a Black woman run business. The lawsuit was filed and then ultimately was settled in September of last year with Fearless Fund agreeing to terminate its grant program for Black women-owned businesses. The same American Alliance for Equal Rights also filed lawsuits against two national law firms that had paid diversity fellowship programs for many years that were aimed at bolstering diversity and inclusion in their attorney ranks. I believe those law firms also agreed to abandon their programs. And so one of the things that my colleagues and I have been doing when we're analyzing our clients' risk in this DEI area is we have to look at Section 1981 risk. So anything that you do that has any sort of a contract, even if it's not a written contract, contracts can be oral, they can be implied. But if there's any sort of contract, especially if it's in writing, and if that program is limited only to people of certain races in particular, that has a very high degree of risk. Frankly, has nothing to do with the administration. And certainly the administration, the Department of Justice could bring lawsuits to enforce this as well. But it's more the private litigation that I'd say is the greatest risk. And then finally, the last area, which is not nearly as widespread, although I expect it to become more widespread, are state laws and executive orders that restrict DEI policies, trainings, and practices. Some of them, like in Texas, only apply to state agencies and state government officials, but one in particular in Florida, Florida's Individual Freedom Act, some people call it the Stop Woke Act, restricts diversity-related training in private workplaces, including nonprofits that are either based in Florida or which have Florida-based employees. And so if you're based in Florida or if you have any Florida-based employees, you should not be you should not allow those employees to participate in any diversity-related training, and that does apply to private nonprofit organizations. I fully expect in the current climate with the current administration that we're going to see more red states expand those laws and executive orders, particularly in the DEI space. So it's something to really keep an eye on. So that's kind of the spectrum of the various legal risks. As you can see, some of it very much has to do with the Trump administration and the executive orders, and some have nothing to do with it, although the tone and tenor and potential legal risk is going to be affected by the administration as well. So whether you receive federal funds, and certainly having to certify non-discrimination and no DEI programs in connection with the receipt of those federal funds with potential criminal penalties is significant. All the employment-related risks, Section 1981 of the original Civil Rights Act, these state laws and executive orders. And then I'm going to give you three other categories of potential risk. One I think is really not something to be terribly concerned about at the moment, but something to keep an eye on. And I get a lot of questions about it, and that is federal tax exempt status. Um, it is not inconceivable to me that this administration and its new leader at the commissioner at the IRS could take an aggressive posture that nonprofit tax exempt organizations that engage in illegal under their definition, whatever that is, DEI programs, that organization should not qualify for tax exempt status because it's engaging in something that's contrary to public policy. Like for instance, decades ago, there was a case or multiple cases that were litigated involving basically like Ku Klux Klan type nonprofit organizations that applied for tax exempt status, C3 status with the IRS, and the IRS declined the tax exempt status, and the cases got litigated, and the courts upheld the fact that we were not going to recognize tax exempt status for an organization that engages in, you know, clearly an activity that's violative of public policy. It's easy to see this administration potentially try to flip that around and take the same but kind of opposite position. And so it's definitely something to keep our eye on, but to me, not something I would lose a lot of sleep over. I think there's a lot more to lose sleep over in terms of what sort of adverse impact on tax-exempt organizations might occur through in the tax bill that is likely going to come up in Congress later this year. By the way, someone asked, how can the president change tax law? The president can't change tax law, but the president enforces tax law. And a lot of tax law, I've been doing this for 30 years now, is interpretive. You know, the IRS interprets tax law. Like Section 501c3, for instance, and C6 of the tax code is very brief, doesn't have much in there. Most of it comes from regulations, from interpretations, from court decisions, and other things like that. And so there is a lot of ability for the administration to interpret tax law. Of course, the administration goes too far, like some people say they have in a number of other areas recently. You know, the courts always have the ability to dial that back. Two other big areas of risk. It's not legal risk, but it's certainly very important for you to keep in mind. And that is kind of member, donor, supporter, funder backlash or lack of participation or lack of attendance. I had a client last week that told me that they had someone from the IRS. It was like a training program, the government training program, and the IRS official asked whether the training program had any DEI content in it, because if so, his boss told him he was not able to register for it. You know, I think we're going to see some of that sort of stuff. We're going to see, de depending on where your organization comes out in these issues, whether you end up, you know, further on a really risk avoidance type posture, or whether you're willing to push the envelope, you're going to piss some people off. There's no question about it. And that's going to have a potential adverse effect on people's willingness to participate, to come to your conferences and attend your programs and buy your products and services and other things like that. So you have to take all of that into account in your overall risk analysis. And of course, the overall reputational risk. There's no question that again, depending on which way you end up, which way you decide to go. We have some clients that are saying, we are not going to be bullied by this administration. We're not going to give up our core values. We have others saying we're not going to give up our core values, but there are a lot of things we can do on the surface to help mitigate some risk without giving up our core values. So, for instance, if you have some sort of a grant program where you give out grants or fellowships or scholarships, and in the past they were limited to only people with certain protected characteristics, you can do what colleges and universities are doing. You can do what the Small Business Administration is doing, which is to say we are no longer going to presume that because you're a minority, for instance, that you've gone through discrimination in the past and are eligible for this SBA loan or, you know, a factor in college admissions. But like Justice Roberts said in his majority opinion in that Supreme Court decision, it is okay for a college applicant to write an essay showing how they've overcome disadvantage and hardship, including because of that person's race. And so, if you're just again, go back to that question, is this program exclusionary? And can we rework it, rewrite it so that anyone who can show that they overcame disadvantage or hardship is eligible, not just limiting it based on someone's race or sex. So those are some practical things that you can do without giving up your core values. You know, perhaps scrubbing your website, again, not to change who you are, your core values and things like that. But we do know that federal agencies are looking at and searching nonprofit organizations' websites, particularly those who get federal funding. Um, and something just to keep in mind. A few other practical tips, and then I'm going to open it up for questions. Um, Number one, don't overreact. Don't put your head in the sand, but certainly don't overreact. Obviously, you have to take into account your organization's overall risk tolerance, not just legal risk, but financial risk and reputational risk and member and donor relations and things like that. Um, but be very thoughtful about it. Obviously, work with legal counsel because some of these issues are certainly legal. Um, and um, don't overact, but be smart about it. Obviously, your board is going to have a lot to say. Not every I've had so many calls with clients in the last few weeks. Not every board is aligned with the staff on these issues. So that's obviously something that you also have to take the pulse of your board, and of course your broader members and donors and funders and whatnot. Certainly consider diversifying your funding streams. We have a number of clients that are international NGOs. These are C3 organizations that generally do relief and development work in developing countries around the world. So many of them are heavily funded by USAID and the Department of State and other federal agencies. You all know what's happening with that, I'm sure. In some of these organizations, it's just devastating. It's absolutely crippling. We don't know what's going to happen going forward, but certainly to the extent you can diversify your funding streams, if you were getting a lot of federal grants in the past, maybe look to private foundation grants to try to supplement those and replace those if necessary. Certainly scrutinize any initiative, and I'm using that term broadly, programs, policies, practices that fall into this broad DEI bucket. And you just scrutinize all of them to see what you can and want to do to help mitigate the risk, to help make you less of a target. Certainly assess your culture and your risk tolerance, your budget, your values, your public profile, your ability to withstand legal challenges, and the significant costs that can accompany them, particularly private litigation, some of which may not be covered by insurance. Dealing with governmental investigations, we deal with these a lot. They can be very expensive. Whether it's, we've already seen a ton of House and Senate investigations in the last 2 years, or I guess 4 years, 2 years in particular. And I expect we're going to see many more of those, and I think we're going to see many coming from federal agencies as well. Um, Design your scholarship, your fellowship, your grant, and other programs using race-neutral criteria to the greatest extent possible. Certainly make sure that all of your employment policies and practices are compliant with all current federal and state legal standards involving things like discrimination, harassment, wrongful termination, etc. Always keep in mind that the employment laws are going to apply based on where the employee generally works from. Obviously, stay on top of all developments in this area, including at the state level. As I said, we have seen state laws that govern that, have, and bills introduced, even getting down into the weeds of things like nonprofit governance and board composition and volunteer leader selection and things like that. So keep an eye on that. And then anything, of course, that involves a contract, as you know, including, by the way, we've even seen it to, like a lot of, it is a best practice for nonprofits to have their board members and sometimes even committee members, sign an agreement at the beginning of the year that says, I agree to abide and disclose any conflicts of interest. I agree to abide by my confidentiality obligations, maybe containing a copyright assignment provision and certain other things. I agree to abide by the code of conduct. These are contracts. And if you're we have some clients that have a board selection and nomination process that has certain slots reserved for certain minority candidates. I mean, that type of a structure, if there's a contract involved, certainly raises some legal risk for sure. But then, if, like, for instance, if there's no federal funds involved, what you're talking about is solely in the governance area or the member area and nothing to do with employment. And if there's no contracts involved, not even remotely, or there's no program that, is exclusionary in terms of certain protected characteristics, then your risk is probably very low from those initiatives. I mean, I can't even point, at least with the current state laws that exist and whatnot, I can't point to anything that would make those sorts of programs or initiatives illegal. Certainly, it might be a target for criticism, member backlash, other things like that. But you always have to keep in mind that you always have to keep in mind that not everything that you do in the DEI space is going to carry with it the same degree of legal risk. You need to really do that analysis in the way that I walked through it today, to analyze, I don't know, all these different areas of federal and state law that might apply. All right, so I went a little bit longer, Carrie, than I wanted, but
That's
we have
okay.
15 minutes, so let's try to answer as many questions as I can.
Yep, we've got a lot. All right, so first up, do any prior grants, loans, loan forgiveness, for example, PPP, put us at risk? And there was an additional question about that too. So prior grants and loans, not current contracts in perspective.
Well, the certifications that are being asked for, it's only prospective. I actually had this question last week from a client. It's only prospective. So I've not seen anything that asks about, what did you do in the past? It's more, what does your program that's funded by a federal agency look like now going forward? Um, so I don't, and I've not remotely heard of anything like clawback of PPP loans or things like that. Anything's possible with the administration, but no, I wouldn't have any particular concerns about that.
Great, thank you. All right, so now we're going to go back to false claims. This person said they saw that they think any citizen could bring a claim. Is that correct?
Yeah, it's not my strongest area of expertise, but I believe there's actually a name for it, and I'm forgetting it. It's basically a whistleblower type provision that if someone brings a successful false claim, like flag it to a federal agency's attention, they can get a portion of the recovery if the federal government recovers those funds. So it's not a private right of action per se, where someone can sue, but there is that mechanism. I actually that might not be completely accurate in terms of how it plays out in practice, but yeah, it's a key TAM suit exactly, and that's what I'm referring to.
Got it. Thank you. Okay, so we're going to go some of the employment stuff. Does including pronouns, email signatures, and on Zoom profiles fall under the employment law issues you brought up?
Yeah, it's a good question. Look, I'm not going to be able to give you definitive answers to a lot of these questions, maybe even very few of them. But again, the way that my mind works as an attorney is that's why I previewed this earlier on. I said we're going to get some questions that people are going to ask, is this illegal? Is this illegal?
Yep.
And you have to drill down into the details. Like, is this in the employment area? Obviously, if we're talking about employees and their email signatures, yes, that's something in the employment area. But then you have to ask what federal or state laws would apply and how would they apply? And so, and this is, let's presume no federal funding because that changes the calculation. Um, but if you just allow, not require, but allow your employees, to use pronouns in their email signatures, it's hard for me to envision how that would violate, for instance, Title VII of the Federal Civil Rights Act or the other, core federal, particularly federal anti-discrimination laws in the employment setting. It's hard for me to do that, but I could also see an enterprising or aggressive plaintiff's lawyer or even Department of Labor official kind of making that argument that it somehow creates a I don't know, I guess an argument to be a hostile work environment for others who don't like seeing that. I think it's a huge stretch. I think if you don't receive federal funds, it's hard for me to imagine us advising clients to ban that sort of practice from an employment law perspective and an anti-discrimination perspective. Now, whether for reputational reasons or I don't know where the members, if it's an association, how they feel. Obviously, it's a different climate we're living in. But from a purely employment law perspective, um, I wouldn't recommend banning that practice. Not the way that the law currently stands.
Yep. So what about drilling down into, team member resource groups and things like that that were kind of organically created by the staff? It's not part of management's programming. If there are resource groups like that, are those subject to scrutiny about this DEI stuff too?
Yeah, this is another tough one. I've been asked about this as well. Look, I mean, I think the safest thing to do, and again, you got to look at your own risk tolerance and how risk averse is your organization, and what are you countervailing? Are you going to really anger a whole bunch of employees if you get rid of certain very popular, employee interest groups and whatnot? Um, Certainly, the safest thing to do would be to eliminate any such groups that are exclusionary based on protected characteristics. as I said before. That's kind of the most conservative, I don't mean politically, but legally, the most conservative approach to take. Others might say, look, these are just voluntary groups. Maybe they were even formed by employees. You know, anyone can form any type of group that they want. Um, Again, I have a hard time pointing my finger at, some federal employment law, whether it's Title VII or something else, that would make that illegal. Again, this is assuming that you don't receive federal funds. And I have to keep saying that because if you receive federal funds, you have to make this broad certification that you don't do anything that is illegal in the DEI space. And we know that this administration has a much broader definition in mind of illegal discrimination in the DEI area than I think some others would.
Got it. Okay, so if you don't receive federal funding, we had somebody, I think this one was in the chat and not in the Q&A, but how would you advise somebody whose board is potentially thinking of taking a public stand that they are going to remain in support of DEI initiatives?
Yeah, we have some clients that are going to do that or are thinking about doing it. Um, Look, it's certainly not an unreasonable or irrational decision. Look, there are some organizations who, and we have some clients like this, it's literally built into their DNA. It's who they are. It's who they, represent. Um, and it's their core issue and cause. So they can't run away from it. They can't give it up. The administration is never going to be a fan of them no matter what happens. Um, and so long as they either don't receive federal funding or they're fine abandoning or giving up their federal funding. Remember, a lot of federal funding has been cut for grants, particularly grants and cooperative agreements that the administration feels are promoting equity and environmental justice and whatnot. And that money's not coming back, in my opinion, in this administration. Some other stuff is, likely or it may survive, but if you're willing to abandon your federal funding, if you're careful to comply with the employment laws, if you're careful to comply with Section 1981 involving contracts and not discriminating on the basis of race in contracting, then I think you're on more solid ground in taking that more aggressive posture.
Gotcha. Okay, so what about organizations that have employees that specifically oversee DEI programming? And also, I believe I saw something about going back to election day and looking at changes on federal contracts and grants to staff titles and descriptions of programs, even going back to look all the way back to November.
I'm not sure what the questioner means by that retroactive look. Um, yeah, Carrie, can you repeat the first part of the question?
Yeah, I mean, so generally there's a couple of questions like this. If they have a DEI specific program or DEI specific staff, and it's under a federal contract, is it just over for that program and for that person in that role? Hmm, we may have lost Jeff. Everybody, if you bear with us for a minute, it looks like we may have lost Jeff for a second, but he also has a dial-in number, so hopefully he can join us via the dial-in number in just a minute. There you are. Jeff, can you hear us? Can you hear us, Jeff?
Yeah, can you
Yep,
hear me?
I can now. Yep, you're back.
Okay, sorry about that. All
Okay.
right, I think the question was if we have like someone who's in charge of DEI initiatives
Yep.
at the organization.
Yeah.
Yeah, I mean, look, again, it probably goes back to the same answer that I gave with respect to, the board that wants to take a very strong kind of pro DEI stance publicly. If your organization is truly committed to these things, it's really important to you, to your staff. Um, don't abandon it. Don't eliminate that positions. I mean, as you probably have heard, there's a lot of like large companies, Fortune 500 and other companies that have eliminated their DEI related departments and senior officials, terminated them, things like that. I'm not going around suggesting that nonprofits need to do that. But like I said before, be smart about it. Make sure that you're not overly reliant on federal funding, um, make sure that you are complying with all the employment laws.
All right, Jeff, maybe we have time for one more question here.
Okay.
Do you see any way in which religious nonprofits are going to be expected to be treated differently from others going forward?
It's a good question. I was reading this story in the New York Times over the weekend about how the USAID funding cuts, essentially elimination of the whole agency, is wreaking such havoc with Catholic and Christian-based charities, particularly international NGOs and others like Catholic Charities, and others, World Vision, and how had the administration basically the criticism was that administration really didn't see that coming and didn't think about all of the adverse effects of some of these funding cuts. I don't know enough from a constitutional perspective, how religious nonprofits may end up being treated differently in terms of some of the court decisions compared to others. That's really not my area of expertise. Um, but I guess the import of that New York Times article is that no one seems to be immune um, from both these funding cuts and the administration's kind of anti-DEI initiatives.
Yep, great. Okay, I know there are a lot more questions that we weren't
We,
able to
we,
get.
we have time for probably one more.
Okay, good. Okay.
Make it a good one, Carrie.
Oh geez, there's so many left.
No pressure.
Um, what about are there new clauses or updates to the force majeure or triggering law clauses and hotel contracts that you recommend updating? That's an easier one, right?
Well, so we've been advising on this for years, in that in the past, we were able to get in our clients, hotel, convention center contracts. Um, Sometimes we would be able to get clauses in there that said that if the state, passed an anti-discriminatory law or the governor issued an anti-discriminatory executive order, that the organization, our client, would have the right to get out of the contract without penalty. And this has particularly been of import for a number of nonprofits in the more red states like Florida and Texas, where these sorts of laws and others like Georgia, where these laws and executive orders do exist. What we've seen, and I think it's a broader trend since COVID, is that the hotels, especially in those red states, are just pushing back so hard, not only on those types of provisions, but on everything. Uh, Hotel and convention center contract negotiations are much harder. They're harder right now for the nonprofits than at any time in the 30 years that I've been doing this, including in that area as well. So I know I've had clients that come to me like our members are furious. They're refusing to go to this state because of this discriminatory law that was passed or executive order that was issued. And generally speaking, that's just not going to be it's not going to give you the ability to get out of the contract without penalty. There are lots of other contract negotiation strategies that we can utilize to help try to, get it switched to a different state with the same hotel chain and other things like that. But there's no silver bullet solution.
Yeah. Okay, well, like I said, there's a lot of other questions that we weren't able to get through, but a lot of them are also like some of the previous ones where people are wanting specific guidance about specific programs and situations that they're in. And I know it's going to be difficult to answer those questions right now. Hopefully we get more clarity as time goes on. We're going to again post Jeff's website in the chat so you can look onto that for it. Jeff is an invaluable resource about all of this stuff as it relates to nonprofits, and he will continue to be that. We'll also post our resource page that we have up right now that has some guidance from lots of different sources about everything that's been happening that's impacting the nonprofit sector. And with that, I'm going to thank
Yeah,
Jeff.
and Carrie, I'll also say that on our website, someone put out the links to the recent articles on the topic. But this is the first of several webinars that I and my colleague Kevin will be doing on this topic over the coming couple weeks. And I believe all of those will be recorded. They're all free webinars. They'll all be recorded, and they'll all be on our website under the recordings tab. So if you want to see follow-up webinars, whether you want to just watch the recording later or participate in it, you can see the recordings that'll be posted after the fact. And then under speaking engagements, you can see links to the upcoming programs if you want to register. This is going to be a moving target. It's a work in progress. The webinar I'm giving today is probably going to be very different from one that I do 2 months from now on the same topic. Pay attention, consult your legal counsel, be smart about your risk mitigation strategy, and don't overreact.
Thank you. Thank you, Jeff, for a great session. I'm glad your Wi-Fi held. I hope you get back
Yeah,
home
thank
soon.
goodness.
Everybody else, thanks for attending, and we hope to see you again soon. Have a good day, everyone.